Meeting of December 17th to order, and please join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I'll entertain a motion or action to adopt the consent calendar.
I'll move that we adopt the consent calendar. The agenda, the minutes from November 19th, 2013, and the minutes from October 15th, 2013.
I'll second that.
Okay, have a motion and a second. All in favor, say aye. Aye.
Aye.
Abstain.
Okay. You've had too many.
Mr. Chairman, I abstain due to my absence from the November 19th meeting. I wasn't qualified to adopt the...
Since we have no items removed, we'll go on to the items of interest to the public. I'm assuming that you're not here to speak to us about some matter, so you're here for a business item, I believe. Yes. Okay. So we'll pass over that, and we'll go to the public hearings. The general plan determination for acquisition of real property at 344 Placerville Drive. And Pierre, you have the report on this.
Thank you, Mr. Chairman, members of the Planning Commission. This is a request by the County of El Dorado for a finding of general plan consistency for a proposed acquisition of real property, and that property being located at 344 Placerville Drive. In accordance with Government Code Section 65402, the county shall not acquire or dispose or any real property in any city if such county or city has an adopted general plan until the location, purpose, and extent of such acquisition or disposition has been submitted to and reported upon by the planning agency as to the conformity with said adopted general plan or part. The county did make a formal request by letter dated December 9th. That's provided as part of the staff report as Exhibit C. Describing the property transactions that are to be considered by your Planning Commission in making a determination for general plan consistency that's required in accordance with Government Code Section 65402. To give a little project description, they're proposing to acquire the property at 344 Placerville Drive, currently owned by Pioneer Plaza Ltd., to use as additional office space for county operations. The subject property encompasses 1.82 acres in size and is currently fully developed with an existing 28,416 square foot commercial office building that currently is in use, containing various commercial and professional office uses with multiple tenants. The property is fully developed, as I stated, with on-site parking and associated landscaping. With regards to analysis regarding general plan consistency, the property is designated commercial by the city's general plan land use map. The purpose of the commercial land use designation is to provide for retail sales and services, including entertainment and other commercial activities to serve the residents of the community. Office uses that serve the general public by a public agency would also be considered consistent with this stated purpose. Allowable uses as stated by the general plan include professional or business offices, banks, studios, retail sales, eating and drinking establishments, commercial, recreational, motels and hotels, retail services excluding fast food restaurants, and automobile sales or service, public and quasi-public use, and similar and other compatible uses. The county stated purpose proposed use as additional office space is expressly permitted within the commercial land use designation. We also analyzed the request with respect to Goal C of the general plan within the land use element, which states The goal is to protect and provide for the expansion of Placerville's commercial services sector to meet the needs of both Placerville area residents and visitors. The county's plan to acquire, approve, and occupy the facility would meet this goal by promoting the renewal of the immediate area. The county's use would also improve economic viability through the provision of public services, facilities and services within the city. Goal E of the general plan states that to promote the development of institutional uses that are conventionally located and compatible with surrounding uses. And Policy 1 further states that the city shall encourage new institutional uses to locate near similar existing uses. The existing building is within a mile of the county's Fairlane Government Center and provides the closest proximity of a building of its size and nature. Given the location, the placement of additional county offices near the existing county government center is convenient for city and county residents alike and would promote the efficient functioning of government services. So in conclusion, it is staff's opinion the proposed land acquisition by the County of El Dorado is in conformity with the City of Placerville General Plan. Further, it is staff's opinion that the locating of additional county offices within the city limits is within the best interests of the city from an economic development perspective, as well as retaining important county government functions within the city limits, City of Placerville being the county seat. With that, I just want to inform you that Mr. Russ Fackrell, he is the facilities manager for the County of El Dorado within the CAO's office, and he will be here to answer any questions that you have. And with that, that concludes staff's report. I'll be happy to answer any questions you have at this time. Thank you.
Questions?
I'll go ahead and start. And I have no issue with staff's analysis in terms of the appropriateness of the use. There's no discussion in the staff report regarding the current tenants and what's to happen with them and their involvement or impact. And would that normally be something that we have an interest in, or is that really just outside of our level of concern?
I'm happy to answer that question. Briefly, it would be sort of outside of the scope of what you're looking at. It's the government code, section 65402, is a very general finding of consistency. So I don't think you would really get into the minutia of what would happen to the tenants. But in past experience, for example, I can use the city's acquisition of City Hall as an example. When the city of Placerville acquired City Hall, it was occupied with tenants. So that would be up to the county. And again, Mr. Frackrell will be able to speak more closely to that. But generally speaking, those leases will still exist with the new owner, and the new owner can either allow those leases to, expire, or they could buy out those leases. But that would be up to the county if they actually acquire the facility.
Thanks, Pierre. Is it safe to say staff really has no detailed knowledge as to what the tenants may or may not know in terms of what's going on?
We do not.
Okay, fair enough. Thank you so much.
So acquire here is purchase, not just a lease from the owners?
Yes, that is correct. Since the county is looking at acquiring the property, they would be actually purchasing in fee title, the land and the building. They would not be leasing it.
How does that impact city coffers? Do we lose property tax? Do we lose or gain at all?
Yeah, the city would not be receiving any property tax if it became government property, so there would be no sales tax there. But basically, I believe the city receives very, very little property tax since the city of Placerville has contracted with the El Dorado County Fire Protection District for provision of firefighting services, and part of that contract essentially provides most of the property tax to the fire district. And so really there'd be a minuscule amount of property tax lost to the city.
Okay.
I have no questions or comments, thank you.
I guess we can have you approach the podium and identify yourself and tell us about your project and maybe answer some of the questions that have been sort of directed towards Pierre, or comment about those things.
Are we ready? Yeah, hi. Hello. Russ Fackrell, El Dorado County Facilities Manager. So as Pierre described, I thought very thoroughly, the county is contemplating the acquisition of this building, and wanted to make sure that we had appropriately ran this by your commission. And we do have a need for additional office space. Currently up off of Fairlane and Fairlane Court, the county's facilities are 100% occupied, and we do have a need for expanding, and this building came for sale, and so we thought that it might, suit the need for future expansion. And is there a specific question you'd like me to address?
Mr. Chairman, thank you. Thank you, Mr. Fackrell, for that information. So I'll just kind of follow up. So in terms of the history of the property, then it became available, and the county looked at and identified it as a suitable piece of property for the county's needs, which is all fine. So, and the property owner certainly is in the position to sell the property. Do you then know what the arrangements with the existing tenants are, or how that's supposed to work, or has the county had any discussion with them? Or
the county has not had any conversation with those tenants. The fact that all of this is so preliminary that we did not want to harm the current building owner and his tenancy there. And so, though we've been approached, we have always directed those tenants to discuss the matter with their landlord.
Right.
And
okay, thank you.
Under extent for the county's plan for the building, do you know which departments might be relocating there?
we have several potential uses for that. The county has some renovation work that we need to do on some of our facilities, so we could see ourselves locating the Chief Administrative Office, County Council, and even the Board of Supervisors in different stages of time into those facilities, while we have to go in and renovate their offices. A lot of the buildings that they're in now were built in 1976, I believe it is, and they have a lot of the same mechanical systems and building systems in there, and they are in dire need. And so,
I was just wondering, because when you said Board of Supervisors, you're not talking about having the meetings there, correct?
No,
I'm just wondering about
it wouldn't accommodate that need.
a
Correct.
larger than normal increase of traffic.
It would only be what we'd be able to occupy in the space of which theoretically the parking was designed to accommodate that office use. And so, correct, we would have to be very
Basically,
mindful
the
of
same traffic impact is just going to come off the hill for a little while and
Yes.
be down on Placerville Drive.
that. That's correct.
Okay.
If I may, Mr. Chairman, and actually, this is a question for staff. So the action this evening is essentially to permit the conversion of this property from commercial to public use. It's going to become public or governmental. It's going to be rezoned.
No.
Count-
There's no proposed rezone with this request, and the city wouldn't require the county to rezone it if they
Okay.
were to use it strictly as
So
office.
this is simply a code compliance matter this evening. The code requires that it come before the Planning Commission before a county sell or acquire property within the city. That's why it's here this evening.
Yes, I suspect, I tried, in the past, I tried to do a legislative review of the history of why Government Code Section 65402 exists. Something happened somewhere in the state upon a government body trying to acquire a piece of property or dispose of a piece of property for that matter. And it's just a simple determination. If the commission were to determine that it's not consistent, it wouldn't halt the county from proceeding with acquisition of the property. We essentially, under the state law, have 40 days upon formal request to make the review to render that finding back to the county.
Okay. So assuming that, and I have no reason to suspect otherwise, that the commission will approve the request this evening, when the county, and actually to bring this back, so uses, and so the county now as the owner of the property, they're going to have to do some renovation work, probably some ADA compliance issues and other things, and some remodeling, and then use of the building. Is that going to have site plan review? Does that come back to the commission with regards to uses? And I think Commissioner Drobish kind of raised the question of, you know, increased traffic and uses that might be somewhat different than what's there now, and what would the role of the commission be at that point?
Staff does not contemplate that any application in the future would come before the commission or come to the city for that matter. Maybe building permit application or something like that, depending upon the renovations. But if it's same for same, so it is built, constructed, and accommodates office, the county's proposing office, we don't see that there would be anything that would trigger a site plan review.
Okay, thank you.
I'm curious about the long-term use. If you're going to use it, you know, to relocate some folks while you refurbish their offices and whatnot, that won't last for more than several months or so. What's your long-term plans for the building?
The refurbishing project is projected to take several years, actually, 4 or more. And so then beyond that, we have currently certain general fund departments that are currently leasing space, which is not an ideal situation for the county. So we'd rather move them into county-owned property. And another option might be at that point, I mean, when you try to analyze real estate, it's what's your exit strategy, and one of those might be that we turn around and sell the property off to another owner, and then we could become his or her tenant, and then we'd be able to put special revenue fund programs in there that is currently leasing space elsewhere.
Okay. Thank you.
Mm-hmm.
I don't know if I missed it. Do you have, if you purchase the property, what are your intentions with the existing businesses there?
Well, they have leases and they're legal contracts that we would have to honor. And some of those folks, from what I'm hearing from the owner's broker, are interested in moving. And so I don't know how we're perceived, if we're perceived as a very good neighbor or not, as far as, do they want to be in the same building with us? Some plan on staying. I think the Center for Violent-Free Relationship is in there, and I know they're asking for more space. And that happens to be a program that our Health and Human Services Agency is contracts with. So I suspect that, we'll try to keep those neighbors in there or those tenants that are in there. We do not have an immediate need for the 28,416 feet. We only need a portion of that.
Okay, that was what I was wondering. Do you need the entire building, or can some stay? All right.
One point I'd like to make, Mr. Chairman, if I may. Mr. Fackrell pointed out one scenario that the county could acquire the property and then in the future sell it and become a tenant. If that were to happen, if the county decides, and should they acquire the property and then in the future sell the property, we would then, again, be before the commission requesting a 65402 consistency review with a general plan for the county's disposing of the property.
And last question, Mr. Chairman, I promise. Just to be clear, Pierre, regardless of who owns this property, any major renovation or alteration, it's subject to the same requirements if the county owns it as if anyone else owns it. Is that correct?
Well, typically speaking, any county-owned property, the city does not require any permitting. So any land use permits would not happen. It'd be subject to building codes and that sort of thing, but typically that would be under building codes, probably reviewed by the county building department. So just like the existing government center, the city does not issue permits, land use permits for those uses. And so where the city would get involved would be if they were to, say, do a dramatic change in use, something different from office, take the building down and do something entirely different, that would be a project under the California Environmental Quality Act. The county would be required to prepare an environmental document that then the city would be able to review and comment on. They would have to mitigate the impacts for any kind of change in use.
Okay. I guess I was thinking if somehow major architectural changes, exterior, were to occur, and getting back to our desire to try to maintain some sort of consistency and a sense of place for Placerville, the county really isn't obligated to confer with the city with regards to those designs. They pretty much have free will to do what they want to do.
That's correct, but it's hard for me to imagine that the county would not consult with the city. In fact, I'm
Okay.
quite sure that they would.
Okay.
They want to be a good neighbor.
Right. I agree with you.
Correct.
So, okay. Thank you.
Thank you.
All right.
Come back to the commission for comment or action.
Well, my comment is, as I'm new at this and trying to understand the purview and boundaries of items that come to the Planning Commission, the way I read the 65402 piece is it sounds awfully to me like 65402 may very likely have been a prescriptive solution to an incident or an event that had taken place within city government before it was enacted in legislation. And our role tonight, and I say this because I can see this being a fairly common event, is that the purpose and the scope of our having this hearing on this agenda item tonight is to satisfy the requirements for 65402 compliance and the public hearing and surfacing of the issues in a public forum. And it seems to me like that's really the main point here, is that we're discharging our responsibility to say we've reviewed it with the consistency of the general plan. We've agendized it and made it public so that everybody has had a chance to read about it in the agenda in the Placerville Federal Register, whatever it's called. But I don't see us having much to say as a planning commission outside of that scope. So that's why, I don't really have a lot of questions or comments about it. So if that's a correct impression, I'll use that as a lesson going forward. If that's not, then please disabuse me of my notions.
Staff would fully agree with that impression. That's staff's impression as well.
I think I was remiss, we didn't close the public hearing, and I didn't ask if there was anybody else in attendance that would like to speak to this item before I brought it back to the commission. So. Okay, so now we can close the public hearing. Maybe take action here.
Mr. Chairman, if there's no objection, I would move that the Planning Commission concur with staff and find that the proposed acquisition of property and office building by the County of El Dorado for general county office use at 344 Placerville Drive is consistent with the applicable policies of the adopted City of Placerville General Plan in accordance with Government Code Section 65402.
I'll second that.
Okay, we have a motion and a second. A roll call vote, please.
Member Friend,
Aye.
Member Drobish,
Aye.
Member Lowry,
Aye.
and now Chair Russell.
Aye. We'll move on to new business, the development guide update. And I believe Mr. Painter is going to handle this for us.
Yes, I do. I've got a brief overview here, and instead of kind of doing what I did last time, which is kind of look at every page to see what amendments I made, perhaps I'd just to give an overview to the public and then open it up if you've got any questions regarding the update edits that I've proposed before you tonight. So again, this is a workshop or project work, or whatever you want to call it, to work on. The Commission's working on this over the winter months. You may remember that when we started this introduction, I was going to provide for you 3 to 4 chapters for this body to review. That would avoid you having to look at the entire document at one time. At the last meeting in November, you did look at chapters 1, 2, and 3. I did also note to you that chapter 4 is going to be looked at by our Historical Advisory Committee, and that'll be this week. So that section will not be considered tonight, because we want to make sure that if there are any proposed edits from the Historical Advisory Committee, that go before you as well. So that will come probably in your meeting in January. The second meeting is when we anticipate having perhaps 3 or 4 additional chapters for you to look at. The edits are made in a strikeout and highlight underline format. As you'll notice in the first several pages, there are very few edits, but most of them have to do with correcting the name of our department now, which has been changed. There's references to the fire department, which we don't have a fire department. It's the fire district. The substantive changes really occur, and I'll provide you with a page number here briefly here. Hold on. Page 26 probably has the most substantive addition, and it relates to the Landscape Water Conservation in Landscaping Act. Some members may remember that about 1.5 years ago I brought this language before you as kind of a workshop discussion item. I think it can be added easily to this development guide because it specifies a specific square footage of landscape area that triggers this. And what better than to put it in the development guide and announce that and provide that for readers to look at when they're developing and submitting projects to the city. That really is the substantive change that I've made before you and provided copies of tonight. Do you have any questions?
In the staff report, it mentions that Appendix D and E have not been edited yet. So I was wondering when E might come back, because our next agenda item, there's a chance to change some language in Appendix E.
Yeah, I'm trying to remember what D and E are. One moment.
Excuse me. Appendix E is applications and procedures and some
Yeah.
forms.
Yeah, that the director and I have talked about that, on whether it's applicable to put application forms as an appendice due to the fact that in many cases those documents change over time, they're rather fluid, and if we alert the reader of this document that applications exist, I'm just using that as one example of the appendice, and we provide links to it and where to find those applications. All of our applications are currently online now, and so we envision making changes to this document to reflect that link, And in fact, eventually, this document will have individual chapters, kind of the way it's set up now on the website, where individual chapters can be clicked on. We envision having the same type of setup with our amendment or update, and then further embed links to the reports or plan documents that have been scanned, or application forms, fee schedules, that sort of thing. The other appendice, zoning matrix, yeah. That will likely need to be tweaked as it relates to potential amendments to the code in relation to our housing element. So perhaps that won't be discussed by this body. We may just leave this appendice out at some time in the future and bring it back at some future time. But there could be additional edits to that matrix that are too nebulous right now to note which zoning categories and uses might be applicable as a permitted or conditional use at this time. So to answer your question, that appendice may not be updated for some time. But we could certainly take input on things that might need to be added to it or something to that effect.
Anybody else?
I will add something. This is not really an action item other than just receiving input. You may remember that when we started this project, that staff was going to assemble the finished document. We'll come back before you for your blessing and recommendation to City Council. So right now we would like to receive input from the public and members of the commission as to the changes that we're proposing tonight. Any additional ones that you guys feel that are necessary, with the caveat that Director Rivas mentioned last time, that this is not meant to be a comprehensive update to this document.
Okay, with that, this is a public hearing item. Open the public hearing, and is there anybody that would like to speak to the Development Guide Update, Chapters 5, 6, or 7?
To begin by commending Andrew and the staff for an exceptional job. It's well written, it's very thoughtful, and it's certainly something the body needs. My suggestion, and it's only that as a suggestion, is that my greatest concern about regulatory bodies in the city of Placerville has to do with consistency. And it seems like in tandem to this, you might want to consider coming up with procedures for how you rule on specific applications that would apply guidelines like those presented here. I hope you'll excuse me if I sound pedantic. I've sometimes thought of that way, but it's not because I went to law school. I talk like this since the age of 5 or something. But in administrative law, you don't exist out of the Constitution. You derive your authority from another branch of government, the executive or legislative. So tonight, when you had one property coming before you for consideration, that might be described as quasi-adjudicatory because it's a specific property and whether it applies to specific guidelines. And when you have something like this, it's quasi-legislative. So the difference in the due process that's involved is dramatically different between the two. So what I was going to suggest to you, because I perceive that to be a big weakness in the administrative process we have in the city. And again, this makes it's hard to present because I happen to like the people I meet here, not only with this body, but the Historical Advisory Committee, some I know personally as friends, I've known since elementary school. So the suggestion I had was you might want to call one of the deans at UC Davis or McGeorge School of Law and get free help. Ask them about guidelines. And I'm just going to give you briefly some of the illustrations that some of you have heard me say more than once. But when I watched how this body looked at the Hangman's Tree building, it was to say, you had this standard about you couldn't have the sidewalks they proposed to stamped concrete because that wasn't historically accurate. And then at a much later meeting, you let them come up with a mural on a neighboring building that has no historical foundation. There's nobody that's ever had a historical mural there. So there needs to be consistency. And then the business community, the public sector, you need consistency. You need to walk into a meeting, present your petition, and know with some reasonable certainty what to expect. And it can sometimes look anything but certain. And so when you have something that, no matter how well written, you have a document like this, you need a parallel set of rules for procedure. So although it sounds harsh sometimes when I've said that, given the choice between ADA litigation with Scott Johnson, which I've experienced, and city administrative agencies, I'd rather have Scott Johnson. It's because of the certainty. I know what to expect with the statute, and I know what to expect with the court procedures. And I really think that with a document like this, I know it's done in stages, but parallel to that good work, you might want to look at establishing procedural regulations for how you operate it. My exposure was with the Federal Administrative Procedure Act and the District of Columbia Administrative Procedure Act, which are virtually identical. And California is a bit different, but they both derive, all these laws, the state, the District of Columbia, and the federal government, derive their authority from the Constitution. So my suggestion would be that when you're drafting an instrument like this, you might also want to, parallel to this, look at crafting some regulations for how you operate that provide some consistency, so that when you have applications, each applicant knows with some reasonable certainty what the procedures are going to be. That's just a suggestion. Otherwise, again, it's well done, and I appreciate the effort, and I know it's a continuing one. Thank you.
Does anybody have any comment or question?
I was looking at that Appendix E, and that all of the procedures are in there for site plan review, variance.
Just a point of order, are we still in the public hearing, or you can close public
I
hearing?
will close the public hearing and bring it back.
Sorry,
Thank you.
Mr. Chairman. Sorry.
Aren't all those procedures listed there in Appendix E? Site plan review, variance.
Yeah, I think procedures are appropriate to put in there, but the application forms are, what I've mentioned earlier, is kind of the fluid document.
But there is a place where the procedures for whatever you're doing with coming to the city and wanting to do are written down.
Yes, it's called the zoning ordinance, right?
Thank you.
Any other comment?
So what I think, may I call you Kurt? What I think I'm hearing you say is that that there needs to be laid alongside our codified regulations, if you will, the process for navigating a permit process or permit request within the framework of those codified regulations. And you mentioned the codes of procedure, and your point of reaching out to local law schools is well taken. It occurs to me also that we might ask subject matter experts, say at the Sacramento Council of Governments or some other municipal governance interest group or association, at what level of sophistication, detail are these procedures normally found, and is it seems reasonable to me that the city of Los Angeles has a very mature set of procedures, and a smaller town may not have, to give the example of Placerville, may not have any. I guess what I'm saying is I think there's a lot of merit in having this, you know, if for no other reason than indemnification, right? But I'd like to make sure that what we choose to do is a match with the resources we have available. If we can get it done, as Kurt suggests, pro bono, that's wonderful. But what I'm saying is that I think the level of effort and detail and the overall word count of such a procedure needs to be in harmony with other cities of similar size and activity. Am I making sense to you?
Yes, I understand what you're saying. I guess my only comment would be, currently, staff is not looking at the zoning ordinance. It's the City of Placerville code, the city code that actually is dictating. It actually, you know, creates the planning commission, dictates how it operates, all of that sort of thing. It's the city code that describes and prescribes how applications will be submitted and what's the process for those to go through the process. Where here, we're merely looking at the city's development guide, and that development guide is for the purpose of the general public, developers, planning commission, for staff, so that when somebody makes an application to develop, say, a piece of property, they have a development guide that reflects what the character of Placerville is and what the city of Placerville is looking for. We can certainly look and review other like cities and look at their development guides and see if there's certain provisions that would work for us. But again, it's focused more or less on when we review, you know, their site plan, the plans that they're using, the type of building, the architecture. We're looking at somewhat of a consistency with a development guide that's suitable for Placerville as opposed to City of Davis or some other jurisdiction. And so when Mr. Smith was talking about the process, the dual process, yes, I fully understand what he's talking about, and our office is always open to him if he wants to come in and talk to us. If there's a particular component of the process that he finds isn't working very well, we can certainly look at that. What generally we do in development services, we just sort of have a drop file where things may come to our attention either from the public or from the developer or from a council member or from internally within staff, and we see there's something in the code that maybe needs to be looked at or revised, you know, and in the future, when time permits, we can go through that process to amend the code, which is a little bit different than it is to amend the development guide. I can talk more about it if you like, but in general, I think that would be my comment on that. That we're
Okay.
not looking at the code, we're just
Right.
looking at guidelines.
And that helps me to understand. I think what's being suggested here is something we should take, I don't like this phrase, but under advisement. I mean, where we're operating right now is in kind of a tactical environment. There are strategic things we want to think about going forward, something we can do. As the defense contractors are very fond of saying, it's something we can do in a subsequent spiral of development.
Just a quick comment. It was interesting that the reference was made to the hangman's tree and the discussion on the historical appropriateness of the sidewalk treatment. And I completely agree with the comment that was brought forth. And I think it's something that the commission struggles with. And then the comparison with the mural issue that came before us. And that really speaks to the standards component and the application of standards. And I think we're all in agreement that the more specific we can write the standards, the less arbitrary the standards are, the better it is for everyone, both this body when it's reviewing projects, as well as the applicants that bring their projects to us. Having said that, however, it seems to me that the scope of what we're engaged with at this point with this document is not a redrafting of the document. What all the changes that I have seen so far are essentially edits to make the document accurate For example, on page 21, there is no such thing as an appearance review committee, therefore that has been struck. Same thing with the yet-to-be-adopted hillside design guidelines. That doesn't exist. It is, in fact, a slope ordinance. Or to bring the document into concurrence with existing laws, such as on page 26, Roman numeral 2, development projects with landscaping of equal to or greater than 2,500 square feet. That's law. And so it seems to me that our purview and the scope of this, and I believe that when staff first brought this to the commission and introduced it, and I had some suggestions about how we presented the public, staff was concerned it was going to get too big, that really we are just cleaning up the document as opposed to rewriting or developing a new policy within the document itself. So that's all I wanted to say.
Thank you. There's no action required on that item, so we can, I think we've pretty well dealt with it, so let's move on to item 9. And I was in error that item 8, you were allowed to speak, but it really wasn't a public hearing item.
Yeah, I think it's wise for any item before this body to provide an opportunity for the public.
No, I think it was a good thing, but it really, technically wasn't required, So, item 9 is something that was brought up, I think, our last meeting. Someone questioned, what does it take, or how do you proceed with demolishing an old building in the city of Nevada? Not Nevada, I'm dating myself. I used to work there. But in the city of Placerville. So, Andrew, you have this also?
I do. There are 3 references within the city's municipal code that deal with demolition and demolition of buildings. And I provided copies of those sections. The first in the list of, or order of, in your staff report is under Title 4, Chapter 11, the demolition of buildings and structures, sections 411.1 to 411.6. This section really describes the role of the building department and the building official as it relates to the demolition permits and requirements for bonding to make sure that when demolition occurs, that there's no damage to neighboring properties, that the demolition material is removed from the site, things of that nature. There's also reference to another section, 10.4.10, historic buildings in the city, and that's a good segue because that's the next section of city code. This section, I believe most of you are familiar with because it triggers historic district review by the Historical Advisory Committee when there are demolitions proposed for buildings that are within historic districts, or when buildings are listed on the city's historic resource inventory. So that section is provided for you as Exhibit 2. And the third exhibit, Exhibit 3, is the section of the site plan review section that calls for, that authorizes the Planning Commission to review applications for the demolition of buildings, again, in a historic district or that have been listed on the city's historic resource inventory.
So, Mr. Chairman, if I may, and I appreciate you bringing this back, and as the staff report indicates, it was something I had brought up. Frankly, I can't remember what the issue was on November 5th. And really, the mind is going. It's just fading.
I think it was there was some discussion after the meeting, and I think it might have been brought up by Member Drobish about a particular building in a section of town that was a demolition permit was issued.
And it was related to the fire. There was a fire
Yes.
up at oh God, what's
The Wiltsey Road.
Wiltsey, thank you very much. So then that triggered my memory regarding the building by C&H, and Pierre, you were a member of the Planning Commission when that came up, and you and I think, were of the like recollection that we thought that that issue was brought to council for a review of policy. Now, in my read of this, nothing has been adopted in recent year, right? All these go back to the mid-'90s, or there was one change in 2010, but I think it was just consistency with new law that was passed. But in terms of city code, or ordinance, nothing has changed within the last 20 years.
Yeah, I think the change that you're referring to in 2010 or 11 was the Secretary of Interior
Correct,
standards.
that's exactly right. So my issue was, and a little bit of my concern is going through this. We have a historic district and we have historic buildings, okay? And I believe, for the most part, all historic buildings are within the historic district, but I'm not entirely certain of that. That may not be true, but.
That is not true.
Okay, so we have historic buildings, and we also have buildings within historic districts. And so, certainly for the demolition part of this, if a building is within a historic district, then certain review, I guess, applies. And that's up to staff. I guess my concern is that the language on 10-4-10 historical buildings in the city, it just seems to me that it should also kind of reference the historic district as well and put some emphasis on historic district, even for buildings that may not necessarily be historical. Now, this may not be the appropriate place to put it, and I don't know how you would want to deal with it, but that's kind of my concern. And I assume that what happened with that structure many years ago would have been subject to fine and penalty as outlined in here. Whether that happened, I don't know, but if I read this correctly, it would have been appropriate for the city to have taken action against them for having demolished that without the permit. So, just for whatever that's worth. You had a comment.
Yeah, yes, I do. The statement you made about, well, 10-4-10, any building within a district that's demolished, whether it's on the historic registry or not, would go before this body. Do you see the distinction? The distinction here is any building, whether it's within a district.
That's driven, pardon me,
Yeah.
that's driven by the permit. So everyone needs to know first and foremost that if you want to demolish a building, you have to get a permit. Okay, right?
As evidenced by Title IV, Section 11, yes.
Okay, so you have to get a permit. Then the city makes a determination, among other things, as to whether or not the building to be demolished is either ahistorical or in a historic district.
That's correct.
And if either one of those apply, then it automatically comes to commission for review, or is there some ministerial level review by staff first? Do you know offhand? I don't mean to put you on the spot.
Well, the question is, yes, the building that is proposed to be demolished, and it's located within a historic district, the provisions under 10-4-10 would apply. And if the request came before the building official and not the planning department first, then under 411, which I'm not looking at the code section, 411.2
Baker.
then it would require review by the Planning Commission, consistency with the 10-4-10, which we talked about.
I'm sorry, does 10-4-10, I kind of read 10-4-10 as only covering historical buildings in historic districts. So I think that was part of my concern, that it was a little bit too narrow, that instead it should talk about historical buildings and buildings within historical districts, which may be of historical interest. I don't know, but
I think I see your
what
point. Yeah, the language reads, no permit for demolition or removal of any building of historical architecture or special historical or aesthetic interest situated, this is a long sentence, situated within the area set forth in subsection C of this section shall be issued without the approval of the Planning Commission. Yeah, I think you could perhaps read into that it's talking about historical architecture and historical buildings. But I think from city's perspective, because the city's established a district and the content and context of that district, there was a purpose for creating that district, and it was for aesthetic purposes, and because of perhaps the people who resided in those homes were of historic figures in the city's past. That's just the tip of the iceberg. There are probably other class. Do you see the, I see your point.
I do, but
perhaps
this
for
also gets
clarification.
back, I think, to our previous discussion about how specific and clear we are with the application of the standards, requirements for review, and so on and so forth. And so I just want to make sure that we're not ambiguous, and that we are achieving the objective, which for me.
If I, Mr. Chairman, if I may, I'll refer you back to Chapter 11.
Please don't refer to
Chapter 11 is the demolition of buildings and structures, so it has a purpose. And under 411.2, it talks about permits required. So basically, under the building code, you have to apply for a demolition permit from the building division in order to demo a building.
Right.
But if you look at 411.2B1, it states, indicate if the building or structure is within an historic district or is identified as an historic building or structure. If the building or structure falls into this category, an application for a site plan review is required by Section 41011 of this code. It must be filed and fees paid. So those are the two cases where a site plan review would be required and would come before this body. If it's within an historic district, regardless of age, as Mr. Painter pointed out, because it's to retain the historic flavor, the character of that district. Or if it's a building outside of a district, but it's been identified as an historic building or structure, it still would be required to submit for site plan review prior to actually receiving the demolition permit to tear down the building.
And this would have applied, in your opinion, because it is my opinion, this really would have applied to the building that was demolished.
And I would defer to Mr. Painter, what exactly constitutes an identification of an historic building or structure. I believe the city maintains a list of all those buildings that are outside of an historic district.
I bet you the one at CNH was simply in the district, though. I'm going back to the one years ago.
CNH.
I'm very, very
CNH,
familiar with
yeah.
that CNH. I also was not happy about that one. I thought that was
Yeah.
a very sound building.
Yeah, correct. And I guess I'm just, maybe this is a rhetorical discussion, but I'm just trying to understand
Right.
if this would have and should have applied, and I'm not suggesting we go back.
To
Please
the
don't-
CNH
Don't, please
issue,
don't
yeah.
misunderstand. I just want to make sure, in terms of the application of the standard, that I'm reading it correctly, that this probably, this was enforced then, and this should have applied to that, and they should have been subject to this process.
Well, again.
Or that building
at-
should have been subject to the process.
At the risk
Let's
of.
take the personal.
At the risk of
aspect
going
it.
back into time, I was here, but I don't recall it. But I don't recall remembering the building, to tell you the truth. But irrespective of that, if a request to demolish the building that was there next to CNH, I have a very good knowledge of what's on the city's historic inventory, and I know of no building at that location that's been deemed historic or was deemed historic by the city council, number one. Number two, that location is not currently within a historic district. Does that help clarify the
Okay,
situation?
yeah, because then it doesn't meet the criteria. But it still should have had a permit for demolition, right? Period. All buildings
I
have to
think
have-
that's a true, that
Okay, so
should
it
be a
have
true
permit for
statement, yeah.
demolition, and then,
I don't think staff knows at this point whether or not they had a demolition permit.
Well, yeah,
I can't
no, right.
tell you.
Yeah, I
whether
don't
they
know.
did.
Again, speaking rhetorically.
Yeah.
That structure, there should have been a permit for that activity, and there may have been. Well, let's just assume there was, but our ordinance requires that there was a permit. And at that time, staff would have taken a look to see what the structure was and where the structure was, and made a determination if an SPR was required.
Right.
Okay.
I believe, because looking at the ordinance that created the language, not created, but was part of the language under Title IV, Chapter 11, looks like it dates back to the 1990s.
Right.
And that building, in your estimation or recollection, was demolished approximately when?
2000.
Yeah, that was before my
Probably
employment here.
2000, 2001,
Okay.
right? Pierre, is that
Yes.
about right?
So
Yeah, sounds about
theoretically, yeah, then yes, that section, a permit should have been issued, bonds required, et cetera.
Yeah, okay. All right. I guess the main thing is, and going back to the introduction statement in your staff report, I was essentially asking staff to please follow up on the status of our ordinances dealing with buildings in historic districts and historical buildings and the demolition thereof. And I think you've done a good job of bringing forth what the applicable ordinances are. So I appreciate that. Thank you.
And you have a comment on this?
Oh, yeah. Basically, I'd like to add some language in here that we have our historic districts. They have some protections. We have our historical resource inventory. Individual structures not in those districts, they have some protection. I don't know how the rest of the Planning Commission would feel about adding to the resource inventory list any structure, say, over 75 years old or built prior to 1930, 1940, what have you, just to bring any demolition of an older structure to a review.
Both of our homes fall in that definition so far. So keep moving it back if you don't mind.
Because as far as I know, no structures have been added to the resource inventory list since it was created and first adopted.
Well, what drives creation of that? I mean, what drives eligibility and so on and so forth?
Eligibility.
How do you get on the list?
How do you get on the list? Those are great questions. It's entirely the opinion and action of City Council. I have had the opportunity to read very old resolutions that Council, when I helped prepare and get the inventory together into a component that can be booted up to the web. I had an opportunity when we had some time to look at old resolutions, and yes, these requests either came forward from a property owner, and they wanted their site, their address, their home, their structure to be designated historic by the council. There were also, at the time the surveys were done in the 1980s, those in mass were deemed and determined by City Council to be historic properties and part of the resource inventory. I think that answers your question. Do we have a particular criteria? No, we do not.
So a couple of things. My understanding is that I'm aware of at least one neighborhood that, as I understand it, was adamantly opposed to being included as a historical district. So it's not a universally loved designation. The other thing that occurs to me is to Member Drobish's comment. This is the civil servant in me speaking. This sounds like something that would be ideal for the Historical Advisory Committee to take up and review their existing list, their existing inventory, and decide when, how, and whether we should go forward with designating properties as historic buildings.
Mm-hmm. That's a good observation. That's actually one of their duties, is to forget the language, but it's to maintain. That's the word. They are in charge of maintaining the resource inventory. But in terms of adding new structures, new sites, new monuments, et cetera, there really is no specific procedure for that. The Historical Advisory Committee could take that on, perhaps, in the future. They are currently working right now to determine, designate, and present a downtown historic district with definitive boundaries and that sort of thing, which we hope to bring to council sometime in 2014. But yes, there'll be lots of public outreach in which this type of endeavor, and that kind of leads me to your point, and in response to your question is that it is very time consuming to do this type of thing, because there are people that perhaps would not be so acceptive of that type of thing, and our historical advisory committee is very cognizant of that, and so they're approaching it very slowly, and they want to proceed very cautiously, and so I will stop there, but I think my other point was that yes, it's part of their duty. I can tell you, I haven't had direct experience with filling out the criteria forms that actually go down to the state for review, but I can tell you from a member of the Historical Advisory Committee who is no longer on the committee, Mr. Clem, who has done that professionally. He cautioned the Historical Advisory Committee about trying to undertake an extensive update of the resource inventory, just because of the expertise involved, the number of man and woman hours to get it done, and it was his advice and suggestion that we look for grant monies to hire a consultant to really spend the time, because it involves not only just looking at old pictures and going to the site and examining the architecture, it's actually investigating the historic ownership of the properties, because like I mentioned earlier, there might be a situation where perhaps the architecture of the building isn't significant. It's the person or family that lived there. It might have been the first brewer that resided in town. It could have been the first mayor of the city. It could have been throughout the name Studebaker. He could have lived there, or you know where I'm going with that. So there are aspects to reviewing and considering this that involve looking at title records, and that's quite consumptive. I'm not trying to push this down or push this aside, but I'm just saying that yes, it is part of their duty to look at these things, and perhaps at some time in the future, if there is grant monies available, perhaps that's something that they will champion to try to secure grant money to do that.
I was just going to answer Commissioner Drovis's question in terms of how do fellow commissioners feel about that, and just speaking for myself, I think it's very clear that there could be both value and detriment to having your property so classified. And in addition to all of the work that you just outlined, Andrew, I think the only way I would, I support the concept, if what I understand Mike is getting at, and I would support that, but I think if there's a case where you have to have absolutely clear, objective, and measurable metrics by which a property qualifies, this would absolutely be one, because you can't just arbitrarily go and change property. And I understand from your description that maybe in the past somebody came and said, I want my property classified as this or whatever. I think moving forward we should be much more specific and have a very specific algorithm or formula that we apply that's agreed, it's gone through a process and it's agreed upon. Otherwise, I do think it's
there could be a building out there that has very specific architecture, and it's the only one we have in town. And saving that from demolition ball, that might be an advantageous thing for the city to do. So I understand what you're saying, and it's not. This is something that the Historical Advisory Committee has talked about, and really how much time, because they are volunteers as well, and we have to be cognizant of that. And I don't want to burden them so much that they've got a lot on their plate right now, and perhaps when the downtown district, if it gets adopted and formalized, then perhaps there's another work product that they can maybe look and tackle. So I'll leave it at that.
Okay. Do you have another comment on this?
I was in the midstream of speaking when it bounced to that side. And just first comment, and who would need grant money when the penalty for demo without a permit is $500 per day? Think about the payday that would be all those days. Added up.
Oh, you're talking about retroactive?
Yeah.
Well, my experience here at the city, we may process one demolition permit a year, maybe on average. And of the 12 years I've been here, it really is very rare.
That's because they're not getting permits.
In regards to,
Sorry. Right?
in regards to maybe not adding structures of a given age onto the resource inventory list, thereby putting those into a category of extra review, my concern is just the demolition part, at least, comes to review of the Planning Commission. So in section 411(2)(b), number 1, it says you have to indicate if it's within a historic district or identified as historic structure. I'd just like to add in there, or more than 75 years old. So just the old structures going up for demolition come to full review of more than one person, say just the building official.
If I may, what I could suggest, just reading through this, the confusion that I see is it's stating that a site plan review permit is required if it falls within a historic district or identified as an historic building or structure. So my question would be, maybe the code doesn't define what an historic building or structure is. So it could be just the inventory that the city maintains, or it could be more than that. It could be, as you suggested, we have some threshold that any building that comes before us for a demolition permit and it's 50 years or older or 75 years or older, then would be required to go through some kind of a review.
Yeah, because I've been told before that it either has to be in the district or on the list. And I'm just wanting to put a given year or a given age to add to it, just for the demolition review.
Because when I read through in your exhibit that you have for 10.4.10, historic buildings in the city, that entire section of the code is only referring to buildings and structures located within an historic district. It doesn't reference a list, an inventory outside of a district. And so that's where I see a little bit of incongruity between 10.4.10 and Chapter 11, because it makes reference to an historic building or structure, and I'm not seeing a ready definition as to what that is.
Yeah,
So we can take a look at that.
that's why I'd like to just get it clarified and set in stone, a given age or a given date, just for demolition, comes to a further review than just one person.
That would be a very easy fix.
I'd also caution you, as we develop these various standards, because let's say somebody wanted to demolish mills. It may not be well known, but Mel's design is an example of a school of architecture called Googie's, which is very well thought of as coffee shop architecture from the mid-20th century, most commonly associated with Southern California. So, you know, let's be careful what we ask for as we parameterize this.
Wouldn't what Commissioner Strobel suggest, kind of protect mills though, and prevent somebody from simply just demolishing it without any kind of level review? Isn't that what he's suggesting?
Well, I think all demolition permits should be reviewed upon their own merits. Not only the age of the building, which I think is should be considered as part of the totality of it, but what the other concern that I have is if you are going to demolish a building, let's say a mid-20th century building, well, what's intended to go in there? How does it harmonize with the other incumbent mid-20th century buildings there? You see what I'm saying is historical is not just gold rush, it's not just Depression era, you know, it's what harmonizes, it's
Right,
it's
and
a-
I think what you're getting at, not speaking against that by any means, but I think what you're tangentially kind of referring to again are those standards. So what are going to be the criteria that qualifies, right? And so I think that's what the real challenge with this is. So let's say, for example, we say all demolitions have to be reviewed, and not just for the historical component, but I mean just in their totality, as you said. Well, then what is going to be the criteria? Because I think what we're striving for, and it goes back to the discussion on a previous item, you know, having consistency in our action and a consistency in our decision-making, and what are the metrics by which we place it. I think that becomes really, really important. Now, having said that, what Commissioner Drobish is suggesting, I see that as kind of putting a brake on it, just adding more structures, regardless of what they are or where they are, but simply from an age perspective, just adding more structures that automatically have to be reviewed. Now, then what do you do? Okay, here's an 80-year-old building that somebody wants to demolish. Now, and so how are we gonna act on that? And what's gonna be the basis that we use to make a decision on it, right? Because we really are trying to get away from the arbitrary aspect of our decision-making. And so then that is what I see as I like the idea a whole lot, but then that's what I see is the concern if we put that into application. Because now it comes before us, now what? Be careful what you wish for, you may get it, right?
Right, and I mean, you know, I have my reasons for wanting to see buildings, older buildings protected in this town. And, you know, but what I hear you say, and I agree, is that we run the risk, I see two risks. Anything we establish as a criteria, we have to be prepared to defend at some point through litigation, possibly. I mean, if we're going to draw this line in the sand, how many resources are we do we intend to expend defending that line in the sand? And the other thing is that as we add other criteria, I think it's going to be incumbent upon those who develop these criteria to integrate them into some sort of a scoring pattern that says, you know, if it's 80 years old and it looks like a railroad shack, that's one thing. But if it's 80 years old and it's mission-style architecture, maybe that's something else. But all of these things we want to do are resource constrained. We've heard that mentioned 2 or 3 times already tonight. So I think they're worth doing at some point in the future, possibly.
As Carol Ann Ogden would say, it's a wicked problem.
I'll check like what Nevada City does. They have an excellent program for, somebody's already come up with a list and a process. There's no reason
To reinvent the wheel.
Exactly.
if I can interject, I've actually read some other jurisdictions. The names are jumbled in my mind, but I've seen them very restrictive, and I've seen them very open and general, I guess would be the term. The very specific regulations would require applicants who want to demolish their building to submit, in essence, a full-blown analysis using the Department of Parks and Recreation criteria, basically hiring, in essence, this is larger jurisdictions, hiring a consultant. The applicant would have to hire a consultant to prepare documentation for a review body to hear. And then they'd weigh that evidence on whether or not the building should be demolished or whether there is something to be saved. That's the extreme. The other side is much more general. In general, in terms of the way ours is set up and specified, which is, yes, it does include some things. There are some things that might be not covered that perhaps could be reined in a little bit more. But I think in the situations, and not the jurisdictions I'm referring to, if I could characterize them, it would be jurisdictions with lots of money. It would be suburban cities that, I'll leave it there. I can just let your mind kind of wonder who that might be. But I'm thinking, if I recall, one of them is in the North Bay of San Francisco. There's another in Southern California that I remember reading. So there are examples out there, and perhaps staff can bring those back to you for further discussion if you'd like. But I do want to remind the commission that, you know, any changes to our zoning code, we must get the city council to okay. You as a body are not allowed to require us to do work product. So we really have to get copacetic from response from council. But that's something we could certainly bring forward to them, and perhaps that might be a discussion topic if we have a joint meeting in the future. That might be something to bring forward and talk about.
Under our list of our job duties is to make recommendations to city council, right? So what do we need to do to bring this item back to put a little more together to send a recommendation towards council?
My suggestion would first be that the issue go back to staff and to the city manager. And when you folks have your planning and discussion meetings, to begin kicking it. This is not something we're going to be able to solve quickly, but to just take it back, that is something that the commission is concerned about and thinks that it warrants attention, and then kind of see where it starts at city administration and where it might go from there. That'd be my suggestion.
Good. I think this has been a thorough discussion, and I think we're leading, or we can see some results eventually or something, but I think we've probably done enough on this tonight, so. Do you have a comment, Kurt?
I enjoyed listening to your comments and thought that a couple of you illustrated the problems about the standard, referring to the Mel's Diner. You know, you have to come up with some consistency, and it's going to be tough. One of the things I was going to mention is, and I will take up Mr. Revis's suggestion and make sure that I look at whatever regulations you have now. But I wonder if you have a procedure for, and just to use this as a hypothetical, you had the Methodist building about to be torn down and possibly replaced with C&H Motor Parts. So if that happened and the city government didn't do anything about it, is there a procedure in your rules for outside parties to come in and intervene, to seek an injunction? That's just a question to consider. But there needs to be that kind of mechanism, I would think. And so to make it up front, if you didn't know, my parents have some property on Main Street in the historic district. I don't own it, but I manage it. And so I know these issues, and that necessarily, you can imagine somebody intervening, wow, extra layer of bureaucracy. But I think it's in the public interest to achieve your goals that option be there. The other comment I wanted to raise to you that's caused me great concern is this reference to the Interior Secretary's guidelines on historic preservation. Here's the issue. When you read that, my interpretation is that if it's not a federal property, it's meant to be advisory. But I've heard the Historic Advisory Committee construe it as mandatory. And that's what made me just go nuts when I watched how, and to use the illustration of the Hangman's Tree buildings, you went from one instance where the city was trying to tear it down, declaring in an affidavit by Steve Calfee that it had no historic value. And then you're coming back to the other extreme where it's got a, and then they were talking about that night about paint segments and, you know, going back and looking at old photographs as if you could tell a lot from black and white. Wow. So the answer is, it doesn't say that. And so I went to the council and asked them for clarification, they never gave it. But you'll need to, I would hope, give some advice on that. If you can show any jurisdiction in this entire country that construes the Interior Secretary's guidelines as mandatory for non-federal buildings, please show me, because my suggestion is it's not. And I just worked on 2 buildings of an historic nature, and one's in the district, the historic district downtown, renovated an apartment building. And it was really a challenge because you tried to preserve the historic nature inside, which we're not required to do, as well as on the outside. So I told the glassmaker, you know, Humphrey Bogart, you go into Maltese Falcon and you see that door, I want that same kind of bubble glass. Sorry, it's not permitted because it's not tempered. You know, there was real challenges, and then the door handle, you know, it's not ADA. And when you want to kind of fudge and use modern appliances in the kitchen, we got a 1860s building, and you got a stone, plaster stone that's 2 or 3 feet thick. So we couldn't put in a garbage disposal because it would have to go through that. So it's a real challenge to do these things with historical integrity. For another, and for my own home, which is 100 years old, and you're all invited, anybody listening out there is invited to come and look. But I did the same thing the tailors are going through now. We had a contractor come in with steel beams, lift it up to get it level, and then put in cement beams. It's a real challenge, you know? Like, I wanted the tile to be period consistent, but what I didn't know is that in those days, tile was cheap. The tile was expensive, labor was, it took about a month to do the tile. It's expensive. So there's just all kinds of issues that when you get into this is really complex. When you want to, with integrity, try to keep it historically accurate. and then you've got somebody telling you that, hey, we can't find an old photograph to justify this and that kind of stuff. It's a challenge. So I would urge you, for the purposes of this document, to look at that issue, because it's going to be a problem. But Mike, your point about how far back you go, I was told with reference to the building on Marshall Way on Cedar Ravine that that was an old building under CEQA, because it goes back to the 1960s. But it sticks out like a sore thumb. My parents used to own that property. The reason it stuck around for a long time undeveloped is because they sold it with a really cheap note, so they just wrote it out until it was all gone. But they could have made that arts and crafts or a bungalow or something that wouldn't have stood out as much as it does along Cedar Ravine. But you all raised very interesting points about what constitutes historic. And that's going to be a challenge. You know, Mel's Diner, when you look at it from up there in the cemetery and you look at the downtown, you got that old historic stuff from the 1800s, and then here's Mel's Diner, the big, but an argument can be made that it's historic. So those are the challenges, but I would really urge you, most important of all, is look at the guidelines, and you, as advisors, I hope, will make an independent determination about, does it really say that it's mandatory for non-federal buildings, or is it advisory? And if it's advisory, it's a big difference. Thank you.
I think you made your point there. Okay. Any other communications or anything from staff?
Yeah, I've got a few. We have some minutes. I did provide you with a copy, and I briefly mentioned before the meeting started. Last week, a week from tonight, City Council amended the committee, commission, and board policy manual as it relates to the attendance policy. And on page 2, what I provided for you is the staff report that City Clerk Zito presented to City Council. And my understanding, I did not attend the meeting, but my understanding is that they adopted it without amendment. So they adopted her recommendations. And basically what it specifies what is and what is not a absence that's excused or not or unexcused. So I want to make sure that you guys are aware of that, since the policy manual affects this body. Second announcement is on the 11th of December, I drafted and sent a letter to former Planning Commissioner Brian Briggs, and I'll read it to you into the record. December 11th, 2013, Brian Briggs, who now lives in Anderson, California. Subject, City of Placerville Planning Commission service. Mr. Briggs, on behalf of the Planning Commission, city staff, and the residents of Placerville, thank you for your service as a member of the Planning Commission. Your diligence in reviewing projects, programs, and other items, issues before the Commission, your careful listening to public comments and input, your thorough examination of the legal framework of requests before the Commission, your calm demeanor while serving as a Commission Chair and Vice Chair, and your camaraderie amongst your fellow Commission members was appreciated and will be missed. Enclosed is a gift from the City of Placerville in appreciation of your tenure as a Planning Commissioner. We wish you well in the future, in your future endeavors. Sincerely, Andrew Painter, Executive Secretary, City of Placerville Planning Commission. He made reference to city staff that he's just not able to come back and officially receive the award and perhaps be roasted by the rest of you. So we thought a letter would be appropriate, as well as sending him the gift. I also want to mention that on the upcoming agenda, which should be January 7th of next year, you're going to be considering reviewing the city's draft housing element. I've got a copy of the document here. I'd like you to pick it up before you leave tonight. It includes a letter from the State Department of Housing and Community Development, which we are addressing their comments in this particular draft. Also included in this packet is the negative declaration prepared for the document. So that's another action that the Planning Commission will offer a recommendation on at the January 7th meeting. And the target date for council to hear this would be the 28th of January. We do have until February 28th to adopt housing element in order to keep our 8-year cycle. So if we fail to do that, then we revert back to a 5-year review. That's even worse, 4-year review cycle, which the city really does not want to entertain at this time. So again, we've got copies of the documents for you here. I'd like you to pick those up when you leave. Director Rivas, do you have any announcements from? No? Oh, Merry Christmas and Happy New Year.
I'd like to wish everyone happy Festivus.
Meeting adjourned.